Good afternoon, everybody. Welcome to today's webinar. Today we're covering what to include in tenancy agreements and where does GDPR leave you. Just a little bit of housekeeping first of all. There is a chat box to the right of your screen. If you have any concerns, or you aren't able to see something or hear something, please do let us know. We are live, so we will work with you to try and get that corrected as soon as we can once you let us know. Just going to record this webinar as well so we can make sure that everyone gets a copy of this afterwards. So if you do miss anything, then do feel free to raise questions during this, but we will go to a question and answer session at the end as well. And then if you want to review it afterwards, we will send you the recording so you can do it at your leisure. Hi Ken, hi Patricia, hi everyone else as well. Just going to now move on to the actual webinar itself. Okay, so first of all, those of you that don't know me, my name is Alexandra Morris. I have been in the private residential sector, particularly lettings, over 10 years, joining MakeUrMove in 2008. What I bring to this is my experience as a landlord and a tenant, and obviously as an agent as well. My passion is helping landlords do what landlords do best, provide good quality accommodation for tenants and support them in anything that they might need by introducing technology through the MakeUrMove platform. What we're going to cover today. So we're going to look at what a tenancy agreement is. We're going to take a look through break clauses and specially negotiated clauses. We'll cover unfair terms, and then we'll look at GDPR, your obligations, how you can become compliant, and how that factors into your tenancy agreement. And at the end, we'll do a questions and answers session. So first of all, what is a tenancy agreement? So as most of you know, you'll put these together quite regularly. A tenancy agreement is a contract between the tenant and the landlord. It can be written or it can be agreed verbally. In most cases, it is written. It cannot give less than the statutory rights to the tenants. It normally includes your express terms and your implied terms. The types of tenancies that you'll tend to issue is AST, which is your assured short hold tenancy. There are others. There are assured tenancies, which some of you may well remember from many years ago. Company lets, which aren't covered by the Housing Act, and regulated tenancies. So the Housing Act 1988, what we're going to look at today is tenancies that are covered by this legislation. So before 1988, we had what were known as protected tenancies. They were often given indefinite rights to stay, and they also had the right to pass these down to relatives. The Housing Act 1988 was brought in to implement changes just to make that whole process a little easier, and then to encourage landlords back into the market. So it introduced rent regulation. So landlords were able to then charge what they liked, and it was normally influenced by the market rates. And they allowed tenants to then challenge these in some circumstances. There was a security of tenure, so assured short hold tenancies. Statutory periodic tenancies were automatically introduced following any fixed terms, and then Section 21 notices. The succession rights were removed so that only a spouse could inherit rental rights from a tenancy. Hi, Patricia. Are you on Wi-Fi? Let me see if I can respond. Oh, apologies for that spelling mistake. We'll work with you, Patricia, see if we can get this working. We're just going through that. We'll try and get through what we can. So maybe if we try a refresh, that will work. Is everybody else able to see the slides and hear? Yeah, okay. 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 If we can maybe try a refresh, that will help, but I'm going to move on to the rest of the slides. So we'll look at the key details of what you need to include in your tenancy agreement. So whether you use a written agreement or not, you are required by law to provide at least your name and address to the tenants. If you also need to, it's best practice to introduce that into a tenancy agreement, but the key details, as most of you will know, is that you have to include the names of all the tenants, details of any other people that you are permitting to use the property, the actual property address, the permitted use of the property. Normally it is for residential purposes, but in some cases you may have businesses that are ran from these properties. You need to include the date of the tenancy start and the duration of that tenancy on a fixed term, the rental amount, how often it's paid, the deposit amount, and how you will protect it. You also need to include required clauses from the deposit schemes, and you need to have details on when and how you can retain any elements of your deposit. You need to detail what happens at the end of a fixed term. So if you'd like this to roll into a statutory periodic tenancy, then you can make sure that's included in that. And you also need to include any services and your notice period, but you must be aware of observing statutory rights with this. And then you also have to include landlord and tenant obligations. So the other thing with the deposit as well is to ensure that if someone else has paid the deposit, you make sure those details are included within there so that you can confirm the right person is receiving the deposit prescribed information. So additional details that you may look for. So there are grounds for possession. There are insurance clauses that you might need to include in there. Can the tenancy be ended early, and if so, when? The responsibility for minor repairs. Now, this is a big area that causes quite a lot of landlords headaches. Things like understanding tenants, how they report maintenance issues, and also what maintenance issues are their responsibilities. You need to include sublet arrangements. So there's a big rise in this with the increase of Airbnb, etc., which is allowing, well, tenants are using this to rent out spare rooms without permission of landlords in most cases. You need to put in there anything that you require permission for and how that they may request it. This is things like pets or smoking or decorating, how they can report maintenance issues or when they should be reporting them, the responsibility for any bills, and what will happen with any interest that you occur on the deposits, the rights that you have for access throughout the tenancy and at the end, and this is particularly important if you want to do viewings, the interest rates for any arrears and reasonable fees, the responsibility for the garden, which is often overlooked in tenancy agreements, leasehold and freehold requirements, and then cleaning obligations. We're going to now look at a particular section of this, which is, can the tenancy be ended early, and if so, when? These are normally used with break clauses. The advantages of this is that you can get a security of a longer tenure if the break clause is not triggered. You can dictate a longer notice period for it to be valid. It gives you the flexibility if you and your tenant are unsure about how long you actually want to be in a contract. The disadvantages are obviously the flip to those. There is uncertainty about the length of the tenancy whilst you have an active break clause. There is often a lot of confusion about how you can use a break clause, and it can sometimes be used in a way which conflicts with statutory rights. So the particular rules around a break clause are you need to implement it at a specific time, which both of you agree in advance. This can normally be done within the fixed term, and it usually incurs a required amount of notice from either party. There doesn't need to be a reason to use it. We tend to use here at MakeUrMove single-use break clauses. This has a set period and an expiry date. So if it's not used by a certain date, it is no longer valid for use in the future term of the tenancy, and the tenancy will continue to run as per the tenure that was granted at the beginning. What we do find a lot here is inadvertently landlords creating break clauses in contracts, which then end up being a rolling break clause. It can be used at any time during the fixed period. In essence, what you also end up doing with some of those is granting the rights to break tenancies before the 6-month point. If you do that, you aren't able to then apply through the courts if the tenant doesn't move out, because you need to wait until 6 months has expired before you can do so. It's important that you understand what you both want to achieve out of break clauses before implementing them, and you agree how they are going to be used at the outset, because you normally only get these issues when they are attempted to use them. It's good practice not to use them within the first 6 months and to make them for use after the 6 months has passed. So we'll have a look now at specially negotiated clauses. The specially negotiated clauses have been around for a while. What you need to do with these is determine them and make sure that they are clearly indicated within your tenancy agreement. So where possible, it should include all clauses that don't change when you incorporate them into your tenancy agreement. So if you have anything that you've negotiated with the tenant that you don't want to put in the tenancy agreement, that's completely okay, as long as you make reference to in the tenancy agreement the requirement for permission and how they can obtain permission, and then you keep a written record of that. Things like anything that's got a degree of flexibility, so if you need to require written permission, for example, no pets is a big one, but you specially negotiate with them that they can have one Labrador, for example. You could put that in the tenancy agreement, or you could leave it under the no pets and keep a separate written agreement of that negotiated clause. It must be clearly highlighted to them. Your best practice is to put these at the end of the contract so that they're not mixed up with the other implied or express terms within the contract. You can agree them verbally as well, but do bear in mind that if you agree something verbally and then retract that later on, you can't rely on it with deposit retentions. The inventory and the condition of the property is often another area that people get confused with. It should be referred to within your tenancy agreement, but it shouldn't be a part of your tenancy agreement. It should be an independent document that you can then use throughout the tenure of the tenancy when you go and do an inspection to record the condition, and then also to use at the end of the tenancy if you need to make any claims against the deposit. So we're moving on to GDPR. The GDPR is the General Data Protection Regulation, and it's a European regulation. It was introduced into UK law on the 25th of May this year. It works alongside the new and updated Data Protection Act 2018. Landlords do have an obligation to comply with those requirements. Some of the questions we get on this is, do I need to make reference to it within your tenancy agreement? The short answer is no. Just making reference to GDPR regulations and your obligations within the tenancy agreement is not sufficient. There is a lot more that you need to do. So the other queries that we often get is, do I even need to be regarding these requirements under GDPR? And the best way in which to go about this is to review the questions that I've set out on here for you, compliance questions. And if the answer is yes to any of these, then yes, you do need to comply. So are you offering goods and services, including accommodation with or without payment? You're normally offering a property in exchange for rent, so that would be a yes. Do you hold and or process any personal information? You're more likely to store and process information around the tenant's name, tenant's contact number, tenant's email address, any identity documents, and you will process them when you do tenant checks, receive tenant checks back from third parties, or process tenancy documents. And the final bit is, are you processing personal data partly or wholly by automated means? In this day and age, most landlords are using computers, they're using smartphones, and therefore it is classed as an automated means. If you use a manual processing system and you use paper filing, you will still need to comply with GDPR. It is a common misconception that all you actually need to do is produce a privacy policy and get tenants to sign it. There is more involved with this to demonstrate your diligence with it. So I'm going to touch on this area, but we're not going to go into significant detail with it, and I'll explain why in a second. So sensitive personal data is a section of GDPR which highlights additional restrictions that you have in order to process or store the data. The Information Commissioner's website will give you a lot more information on this. So if you do have anything that you feel is sensitive personal data, take a look at their website, because they can talk you through what you need to do. The main bits are that everyone has to have a lawful basis for processing data under Article 6, but in addition to that, you also need to satisfy special conditions for processing that under Article 9. So you must determine whether or not you are using sensitive data and how you deem it to be sensitive data within an assessment. So I'm going to talk you through how you can be compliant. What are the steps for compliance? So the first thing you need to do is assess whether you need to comply. I think the question compliance list that we've just gone through kind of assesses that, yes, in most cases, landlords will need to comply with these. The next step would be to map out what information is held and how you use it or share it. And then after that, you assess whether you have a lawful basis for processing that personal information. I'll touch on the actual gateways for your lawful basis in a further slide, but just to touch on here, where you need consent, there is a high standard for collecting and recording it. So if consent is one of your bases, then you will have to introduce a further element to this bit. So once you've done those 3 steps, you then need to draft a privacy policy or check if you've got an existing one that incorporates the principles and rights of the individuals. The final step is investigate the third-party data processes and check that they are satisfactory and also meet your privacy policies with GDPR. I'm going to touch on each of these bits in a bit more details. Yes, Chris, you will get a copy of slides. I'm hoping that people have managed to resolve their issues with this. Yeah, there you heard me. Thank you. Okay. So the mapping of data, which is one of the first steps, and it's actually one of the things that a lot of landlords miss, because as I said earlier, they will just go straight to producing a privacy policy without really understanding how they're collecting, using and storing data. So the first thing that GDPR requires you to do is identify the person responsible for collecting, storing and holding the data. Once you've done that, you need to map it out. You need to understand how you receive it, what that data is for, whether it is sensitive, how you're going to store it, how you share it, and how long you will store that data for, and how you will remove it if you have a request to do so. There is, oops, sorry about that. There is an example here for how you can do this, because the other requirement that you have under GDPR is that you need to record this process, and this will allow you to demonstrate, if you are ever requested to do so by the ICO and other parties, that you have considered all ways in which you store and use data, and that you have determined your legal basis for doing that. So the responsible person is normally landlords. I have suggested a table here for how you can do it, in which you highlight what data you receive. In this example here, we're saying tenant contact details normally received from an agent. You may receive it directly from advertising that you do yourselves. The use of that is that you will store it so that you can include the names, number and email, and that this might be stored within your within your smartphone. It might be stored within a tenancy agreement. It might be stored within a record that you keep on a computer. These are all the things that you need to track. Is it sensitive? The answer is no on this. There is a breakdown of what is considered sensitive information. At the end of this, you'll get a copy of the slides, a recording, and also a GDPR guide. Within that guide, it's much more comprehensive. You will have these templates for you to fill out yourself, and there will be a breakdown of what is considered sensitive. Just to touch on it personally, it's more if you are collecting information about someone's health. This might affect you if you have a tenant that's got a disability. So you need to be careful about the type of information you're retaining on that. How you store information. So like we've already touched on, it will be normally within your smartphone. You might store it in a cloud-based solution or on an actual computer. If you are storing it on a computer, you also need to consider security. So make sure that you are storing this securely and it can't easily be hacked. You need to determine how you're sharing this data. If you are meeting a tenant and then you want to agree a tenancy, you may well refer this over to a referencing company for them to complete on your part. So this is a third party that you'll be sharing the information with, and it's important that you highlight that within this table. So you put the name of the company that you'll actually be sharing it with, how long you'll be storing it for. You may decide that you have a right to retain this information for 1 year where an application has failed, but for other obligations, if a tenancy has gone ahead, you would be required to retain some of this information for up to 6 years after the expiry of the tenancy. An example of why you would need to do this is for HMRC. You are required to retain these records, so you do have a right to store it for that length of time. If you are requested to dispose it, or at the end of these time periods, you need to determine how you will dispose of it. So this might just be simply deleting the file and making sure that there is nothing traceable from your computer and getting rid of the contact information from your smartphone. So we'll move on to lawful basis, which is probably quite a hefty task. The default position that a lot of people previously had under data protection was that I've had consent. Consent is not the ideal way to process this, because it can be withdrawn at any time. And if it is withdrawn, then you're left in a scramble to try and demonstrate under GDPR why you still have a reason to store and process this information. It's quite obvious that for an existing tenancy, you're going to need their contact information for dealing with maintenance, for dealing with renewals, for any access that you need to get. But if they told you that they wanted you to remove that, they didn't consent to you restoring it, and that was the only determination you'd made, then you would have no rights to retain that information. You would have to demonstrate it through another gateway. Now, gateway is the name that is given under GDPR for lawful basis. So your gateway to the data and the processing of that data will normally come under one of these 6 things. So consent is express. Tenant has to give it you. You have to record it, and you have to make sure that you use the data in specifically the ways that you told them you will do. For the performance of a contract, this is where you will largely determine that most of your data storing and processing is covered under this, because in order for you to carry out your obligations under the contract, you will need to collect certain information, and you will need to store it, and you will need to process it. Legal requirement is the next one. So legal requirement, if you are legally required to hold on to information, such as right to rent records, passport identity documents, tax records, the amounts of rents that you've received, and the amount of maintenance costs that you've paid out, etc. These are all classed as a legal requirement for you to keep it. Vital interests, if it's required to protect the vital interests of the subject. Now, you may have this if you have some, again, sensitive data. There may be a requirement for you to keep that, and it's vital to the party. If there is a public interest, such as national registers, for example, these 2 are unlikely to apply to most landlords, but they are still there as an option. A legitimate interest, if you are pursued by the data controller or third parties, if it's mentioned within your privacy policy and you disclose that to the third parties. So for example, if you one legitimate interest for you guys as landlords is to process data for the purposes of obtaining reference checks that would be satisfactory to then allow you to move to a contract. You would be allowed to use this gateway in order to do that, as long as you disclosed it to that party within your privacy policy. So you tell your tenant, I'm going to be transferring your information to this company in order to do reference checks. Consents. So I did briefly touch on this in the last slide. There are 5 requirements for consent. These are the principles of consent. So it has to be obviously given, which means that you can't hide it in a clause. You can't have an automated tick box if you're using web pages. You must ensure that anyone else that you're passing this information to also observes that. It has to be freely given. You can't require consent. For example, if you are wanting to pass their data on to a utility comparison provider and you get a kickback for that, you can't just tick that into your contracts and be okay. You have to actually expressly ask the tenant if they're okay to do that, and you cannot require them to do it in order to get the contract. The request for this consent needs to be very specific. You need to detail exactly who you will be transferring that data to. And then it needs to be clearly informed. So it can be online, in writing, or verbally, as long as it's a clear affirmative statement. And it can also be inferred from the actions of those. The best practice is to get a written consent form and detail within that written consent form why you're asking for this, what you're going to do with it, who you're going to share it with, how they can withdraw their consent afterwards. If you determine that consent is the only legal basis that you have for processing data, this is the only way in which you can go about getting consent. And as I said, it can be withdrawn at any time. So it is always best practice to try and use one of the other gateways. So once you've carried out an analysis of how you store that data, the next step would then be to produce your privacy policy. So you've determined that GDPR applies to you. The first thing to do is register with the ICO, and they have a tier of categories depending on the size of your organisation. You can visit their website, and it's a simple process to do, and you just pay the annual fee. And this then supports that you are aware of your obligations under GDPR and you are observing them. So the ICO are the authority, they can request information from you with regards to your data mapping. When you create your privacy policy, if you've used some of the tools that will be in our guide for you, you should have already done most of this tracking. But you need to outline how you receive data, how you store it, the reasons that you're collecting and storing that data, i.e. if you've got a lawful basis, how long the data will be retained for, and you have to identify the rights of the data subjects. So the principles for rights of data subjects outlined include, and this is only a very small list of these, the right to be informed, which is usually met by your delivering the privacy policy to your tenant, the right to rectification. If a tenant notifies you that there's a spelling mistake, you are required to amend that spelling mistake. You usually have a month to do this. A right of access. How can the data subject themselves access their information? And if they do access it, how are you going to provide them with a copy of anything you hold? And the right to erasure. So there are specific circumstances which apply to the right to erasure. You must comply if you receive a request from your tenant for erasure, unless you can retain it for the following reasons. So if you processed the erasure, doing so would interfere with the freedom of expression and information. You can't erase this information because you have to comply with a legal obligation, or it's needed for your exercise or defence of any legal claims. Third parties. So you've mapped out your data, you've identified a couple of businesses, companies, third parties, partners that you may transfer that data to. If you do process data with third parties, you have to ensure you have a contract in place with them, outlining exactly what your purpose is behind the processing of that data. You need to check and satisfy yourself that they are GDPR compliant. The normal way of doing this is to download their privacy policy and just keep it in a file. And you need to also check if they process data in third countries. If they do process data overseas, you need to check those countries are approved for GDPR purposes. This is particularly important if you look at servers. So where is the server based for the cloud-based software that you use, which is essentially where that data is stored. What are the chances that a landlord will ever be challenged on this? Yeah, so the truth is it's highly unlikely that they'll come after independent landlords. They have the policies behind GDPR are more linked to business, but as landlords are identified as a business, it is really important that you just tick through this. And once you've done it, it will take you some time to get there, but once it's done, and you just need to then maintain it. So check it every year, make sure that you're up to date with the new regulations or anything that changes. But yes, it's unlikely you will be challenged. The only other thing is that data subjects are now aware of their rights under data protection. So the other thing is if you are registered with the ICO, a tenant has a right to make a complaint about their use of data, and that will then lead to an investigation. It may be a formal one, it may be an informal one. Giving you a specific chances is not possible. At this moment in time, I believe there are cases that are being actioned, but they are on a bigger scale. Data breaches. If you need to make sure that you know what to do in the event of a breach. The main one is to report it to the ICO as soon as you become aware of it. And this does depend on the type of breach that's occurred, but you also may need to notify the data subject themselves. Now, this applies to you even if you are processing data through a third party. So you may get an email from a company saying our systems have been hacked. It's indicated that some information that you've provided to us may well have been lost. In that situation, you would be responsible for notifying that data subject. So just be aware of that. So in summary, the steps to compliance and making sure that you're on top is to assess your obligations, assess your requirements by mapping the data and the use and the storage, register with the ICO, determine that you have a legal basis and what that legal basis is, record any decisions that you make on this process in a GDPR booklet, if you like. It will be a booklet once you've gone through this. Produce your own privacy policy and make sure that privacy policy is delivered to anybody that you interact with that you then store data for. Ensure that you protect the information securely, and then continually review your policy and processes to check you remain compliant. The GDPR guide that we're going to send out after this is, as I said, it's quite a lengthy document. It does have a few templates in there for you to use to do these things, to map these things out. And there's a lot of further information in there about how you can review your policies and processes, and covering sensitive data and security as well. So that's the end of this webinar. The next webinar that we're running at the end of the month is titled When Things Go Wrong. This is going to centre around arrears, how you can deal with arrears, and possession. What are the merits for possession and how can you go about it? We're actually going to be joined by a legally qualified person from Helix Law called Alex Cook. So do register for that one. We'll send you the links out as soon as we can. And the guide obviously will come over along with this recording. So are there any questions besides the ones that we've asked throughout? No problem, guys. I hope you found the information useful. And as I said, we'll get the slides and things over to you. So we should get that done as well. If you do have any questions and Vincenzo, will the ICO register? I'm not sure what you mean. So yes, definitely register with the ICO. You get a confirmation, you'll get a registration number, and then you'll get a reminder to renew that annually. Okay, so do you mean that like templates for your privacy policy and things like that? Yeah, so there are some guides. The ICO website is very comprehensive, so it can feel a little bit like you're reading a different language when you go through the steps on there. Our guide has taken some of that information and various other sources, and we've just tried to make it a little bit more plain English. The guide does have some templates for you for mapping data, for storing data, for reaching decisions, which will all help you with your diligence to make sure that you have observed the GDPR. But yes, there are plenty of guides out there on the ICO site and other organisations. The RLA might be a source that a lot of you have used as well if you're members. They too have a lot of guides on there. No problem. Are there any more questions? There isn't a time limit, so there is no grace period. You have to be compliant now. So if you are processing or storing data, it is important that you are aware of what data you're processing and storing, and that you have a legal basis for doing that. If you've got tenants in place already, carry out this mapping exercise and then produce your privacy policy and then issue it to those tenants. Yeah, consent should not be relied upon. I'm not saying it's not good enough. I'm just saying that it shouldn't be your default position, because it's very difficult to prove that they still consent. So you may get a written document that says, yes, I have consent to do this in this way. If there was a complaint made against you, that document would be fine. But if the tenant then said, oh no, I told them I didn't consent anymore, it'd be very difficult to actually demonstrate it. So the recommendation is not just to rely on consent if you have other ways. So for example, a landlord can store information about a tenant for the performance of a contract and legitimate interests of a third party, so processing it out to reference agencies. You don't need to include a specific clause for GDPR in the tenancy agreement. The tenancy agreement should make reference to your data protection policy and then give them a separate copy of your data protection policy. That's what you need to do. Yeah, and Joanne, you make a good point. It's important that you touch on contractors as well there. So if you store any information that relates to a specific party of a contractor or a company or individuals within that company, they too need to know what you're doing with that data. You do need to provide them with the privacy policy too. Basic letters to your tenants are fine, your existing tenants, as long as they include your privacy policy. And as I said, your privacy policy, yes, it is a bit of a minefield. Your privacy policy details absolutely everything that you store and how you store it, and then your legal basis for doing so. It just needs to also give them information about how they can make a complaint, how they can access that information, and how they can withdraw it. Yeah, it feels like a minefield. I assure you, once you've gone through this exercise of mapping the data and determining your lawful bases and then producing your privacy policy, it will make sense. It is a structured step-by-step process of doing it, and once you've done it, it will make complete sense to you. Data protection policy is the same as privacy policy. The privacy policy essentially is the document that you produce that observes your data protection privacy. Thank you, Joanne. Okay, if there aren't any more questions, I know we're finishing slightly ahead of time. We'll close this off. Thank you very much for attending today, and we hope to see you on future webinars. Yeah, Vincenzo, there'll be a recording. I'll get a recording sent out to you as soon as it's filed up. That will be probably within the next 24 hours, maybe early next week. And we'll also get the documents out to you as well. So you'll get a copy of the slides and you'll get a copy of our landlord guide to GDPR. Thanks, Ken. We'll see you at the next one. Okay, guys, I'm going to stop the recording now, and then I'll end it. You'll get a follow-up email shortly. Any questions that you have that you didn't want to raise on here, do feel free to get in touch with us. That's what we're here for. Okay, enjoy the rest of your afternoon and have a great weekend.